Okay, we are on the record. This is the Land Surveyors Board, and today is Tuesday, November the 22nd. This is a teleconference call, and here at the office in room 1B, this is Roxana Gamusio, the executive director. Laura Martin is with us. She's the attorney for the board, and Kimberly Whaley, who is the director for licensing, is also here to help us with this RFP program um, uh, review. And I'd like to go ahead and make sure we've got everybody on the phone. So as I call out your name, if you can please let me know you're there. Mr. Tim Lingerfeld,
I'm here.
thank you. Mr. Jay Kaufman,
I'm here.
and Mr. Gaylon Northcutt.
I'm here.
Fantastic. We are all here, and I'm going to turn the speaker over to Laura so she can do the reading of the statement of necessity.
Good afternoon. According to Tennessee Code Annotated Section 8-44-108B2, if a physical quorum is not present at the location of a meeting of a governing body, then in order for a quorum of members to participate by electronic or other means of communication, the body must make a determination that a necessity exists. The purpose of today's Tennessee Board for Licensing Land Surveyors meeting via teleconference is to discuss approval for a request for proposal for computer-based testing. While it is imperative that the board address this issue in a timely manner, the physical presence of a quorum of the members is not possible at this time. Therefore, the board has determined that it is necessary to allow participation by teleconference. Due to the impossibility to have a quorum of members physically present, the board believes the necessity exists. And I need that statement to be adopted by a roll call vote.
Mr. Tim Lingerfeld,
Yes.
Mr. Jay Kaufman,
Yes.
Mr. Gaylon Northcutt.
Yes.
Thank you. All accounted for.
Okay. I think the primary emphasis of what we are to review here really lies under the section entitled "Scope" for the contractor. Galen, Tim, is that pretty much your understanding of that's the area that we need to be reviewing, and that the majority, if not all of the other, is pretty much covered by Laura Martin and legal? Is that correct?
Yes.
Okay, Galen, you agree with that?
Yes, I think so.
Okay, yeah, and that's where I spent most of my time in reviewing what was provided to us. I definitely want to give a big round of applause, so to speak, to Laura and her staff and all those that were involved in drafting this RFP here. Did an outstanding job.
Thank
there
you.
were lots of long hours involved in that, and lots of reading and editing and modifications, and you did an outstanding job to the point that I just have a few comments to make on it. Certainly want to hear what Tim and Galen have to say. I trust that they've had an opportunity to review it over as well. Is that right, guys?
Yes. That's fine.
Okay, all right. I guess without going into those other sections, I'd like to jump down to the area that defines the scope for the examination, and just start off right there in section A1 and see if there's any areas. As we'll just kind of progress through it. If there's any areas that need some attention or changes or suggestions there, and just speak up if there is. A1, I personally did not have any editing or comments involved in that. Anybody else?
No. No, sir. No.
A2, same thing?
Same thing.
Okay, good. A3, I had one comment on.
Oh, wait a minute.
I'm sorry, A2A, excuse me, A2A.
Okay.
I'm sorry. A2A, the only comment I had was at the end of the first sentence, at the end of the first line, where it says specific to the practice of surveying. I'd prefer for that to read specific to the practice of land surveying.
Okay.
Again, these are just minor changes really that I have.
Okay, and that is an A1?
This is an A.2.A.
A.2.A.
At the end of the first line where it reads to the practice of surveying, I'd like that to read practice of land surveying. Again, if there's any objections or other suggestions, please speak up.
I'm good with that, Jay. Yeah, I'm fine with that. I'm having a hard time locating. I see A2, but under section A, mandatory requirements. Is that where we are? Or are you further down?
No, sir. I'm still on the first page. We've got,
Mr. Northcutt, he's focusing on the scope of the contract, so if you have the entire document in front of you, it's probably gonna be in the last couple of pages. That's the part that is specific to land surveyors.
yeah, I think it's about
All the way down?
the 32nd page, I believe is where it is.
Okay, 32nd page. That's good.
That's correct.
I'm down to somewhere in that neighborhood already.
All right.
Give me a second.
Give Galen a minute there to catch up
Of course.
and make sure that we're all on the same page. It's right around.
Okay,
A2,
I'm looking at A2A,
Okay.
and they say the last paragraph.
No, sir. No, sir. On section A.2.A, at the end of the first line.
The practice of surveying could be land surveying, and I agree.
Okay. Again, just minor. Okay. I did not have any other suggestions on A2A. Anybody else?
I'm good.
Okay. Galen?
No, that's fine. I think that's a good change.
Okay. Laura, Roxana, please speak up at any time.
Absolutely.
We're fine with that change.
Okay. On section A2B, I did have two suggestions.
Okay.
The first suggestion would be in the second line where it reads production or correction of a deed description.
Mm-hmm.
I think that should be changed to production or correction of a description. And the reason I say that is, or actually, excuse me, it should be production or correction of a land description. And the reason I say that is, by definition, in section 0820 3.03, we give a definition of terms, and the definition we use is land description.
Okay.
It's really just terminology, but I want to keep it consistent is what I'm after.
That is 100% accurate. And Mr. Lingerfeld, this, you may want to add, one of the points you sent us was about this piece to see if now with Mr. Kaufman's suggestion, are you okay with that?
Oh, yes, ma'am.
Okay.
So if we change this to land description, you don't believe there's a conflict between A2B and A3H? Or do you still think there's a conflict?
Well, A3H is going to have to be modified in
Okay.
the same manner that Jay recommended.
Exactly right,
But
yeah.
I still think there is a conflict between the two.
Okay, I tell you what, that sounds like a topic of further discussion, and I want to get to that point, but if we could handle just these little subtle nuances here, I think we can knock these out real quick and then get back to whatever.
Yeah, that's fine. That's fine.
Okay,
Sorry.
also with A2B, on the third line down it reads, requiring the production of a subdivision plat. I'd like to remove that word subdivision altogether.
Okay.
And again, that also carries over into A3H as well, where it reads the same.
Okay.
Tim, Galen?
Well,
I'm looking up something as you speak.
Yep.
Yeah, I'm looking at that. You know, and past exams have been given, Jay. We asked the examinee to take and produce for us a subdivision plat, taking a piece of or parcel of ground that has been partially depicted or depicted, and do those particular things that put onto that plat, those things that are required for subdivision work. And are we going to take that out of this particular thing and just make it a quote plat?
Yeah, that's not my intention. My intention is by removing the word subdivision, it still allows for a subdivision plat to be used, but it also allows for other styles of plats as well.
Mm-hmm.
Okay, as long as it does not do away or negate the ability for us to require them to do a subdivision plat, and I don't have a problem with that.
Right.
I don't know what Laura will say on that.
Galen, in our syllabus for examinations, that's what I was looking up. it speaks to the plotting of land and subdivisions thereof.
Okay, that's fine.
Yeah, and I think by
So
by
the way
removing
Jay
the
has
word-
right, the way Jay has phrased it, I think would be fine.
Okay, as long as it does that and it does not negate using, us requiring a subdivision, or, the examinee to take, this piece of paper and do a subdivision, that's okay.
Right.
Well, the other side of the issue, Galen, is the fact that as we continue with computer-based testing, then it will be more innovative item type, such that they won't be necessarily hand drafting anymore. It'll be things that will be relative on the computer screen that they can do.
Yes, I understand that too. As old as I am, I still understand that.
All right. All right. Also, one more suggestion I had under A2B on the second paragraph of A2B, where it reads, "The contractor shall provide the state with a bank of questions." I think what might be more appropriate in that situation is using the bank of questions, inferring that there is only one and only bank,
Okay.
as opposed to multiple banks or portions of banks.
Okay, I can make that.
Well, the other thing that I had there, Jay, was on down in A2D, it uses the language, the approval of the board or the board's designee. And, we've spoken about coordinating with the vendor, the contractor. And I wonder if that language would not be more appropriate in that sentence as opposed to provide to the state. Or provide for the approval of the board or the board's designee.
Sorry, let me ask, do you want it to say the contractor shall provide, the state the bank of questions?
No, see, what I'm saying, Ms. Martin, is if the contractor provides the state in this case would be Ms. Roxanne's office. Well, I don't know what Ms. Roxanne's office is going to do with it, per se, no disrespect. But what I am saying is...
You want the contractor to provide it to the board or the board's designees?
Yes.
Okay.
I think that's in the spirit that we've been going with this thing.
I think that's correct. That's a good catch there. Yeah.
And it actually, I failed to mention that in A2A also, because it says the same verbiage up there.
What if I write the state and then I put and dash or the board?
I think, Tim, if
I really think that we should be able to have, I want the director of the board to have the power to request this if they need to.
Using the board's designee?
The state and or the board.
Board's designee.
I don't have an issue with the state having the power to request it. The question that I have is that the sentence says to review and use in development. That's what the sentence says. In other words, it doesn't say the contractor shall provide the state with such and such to go on a vault or something. It says it's to provide it for reviewing and using in the development.
Okay, we can just make it say the board or the board or the board's designees there.
I mean, once the bank is put together, I wouldn't have any. I'd have some security questions about it, but at the same token, I wouldn't have a terrible issue of the state being able to have it. But at the same token, I don't know what they do with it.
And in reality, I'm sorry, I thought it was, in reality, the entire database of questions, like you said, once they're turned over and worked on, they kind of will go to this contractor to take care of, and all we'll be reviewing are the problem questions, if that makes sense.
Yes, ma'am.
Yeah, I don't think any of us will want the database of questions unless we're transitioning and, heaven forbid, leaving a vendor and having to do something else.
Correct.
At that point, that designee then becomes important because they've got to be that trusted entity, and it would likely be the legal department, to be very honest with you, as opposed to me, or someone in the office. They have to be cherished questions, or the whole thing is ruined.
Right.
Yeah.
I'm comfortable putting board or the board's designees, but I feel that we need to keep the state in there because this contract is gonna be technically between the state on behalf of the board. So I want to make sure that we're being clear about everyone's parties here in the contract. So I would like it if in both A2A where it says provide the state and then also in A2B where it says provide the state, I can change that to the state and the board or the board's designees. Is
I'm
that
good with
something you could be comfortable with?
I'm good with it.
Okay,
No problem there.
I'm good with it.
okay. I think that in the end it will function the way that you want it to, but this way our contract is still clear.
Okay.
Okay.
Okay, any more issues with A2B there before we move on? Okay, over in A2C, I did not have any markups on that one. Anybody? Tim, I thought maybe you might, since it employs the psychometric review. I know you're a little more up to date on that than I am.
No, I didn't have any question with it. I think it's fine. The psychometric review basically was what Ms. Roxanne was addressing about either the simpleness of the question or the difficulty of the question to maintain a more uniform exam.
Okay. And Galen, anything there?
Yeah.
Okay. All right, moving on to A. Go ahead.
I'm sorry.
All right, let's move on to A2, Section D. I did have a question on the second paragraph, and I'm trying to understand exactly what the point of this paragraph is in the sense that it says that the board or the board's designee, on its own initiative, I'm kind of questioning that on its own initiative. Can we define, can somebody help define to me exactly by board designee? Are we talking about the regulatory office? Are we talking about Roxana in her position alone? Where are we exactly going with that designee?
Designees can be anyone that the you're going to hate this definition. The board designees are anyone that the board designates to be able to do this thing. So, for instance, you might have people in the field who you think are respected, and the board can vote to say that land surveyor John with, Jay is going to conduct this review, and then the board appoints him as a designee.
Okay,
Or the
so-
board can say, we're going to go ahead and give our executive director, Roxana, the power to review it because we want to make sure that all of our questions concerning rules and laws are up to date. So that's that's why it's left kind of, the definition is sort of left open in that way so that you can use it the way you need to.
Okay, yeah, I'm comfortable with that.
Okay.
Where I started to have some question was where it says here, may on its own initiative. So that's the initiative of either the board or the designee can reject or request modification of examination questions.
Jay, I think this goes back, remember at our last meeting, we kind of talked about that in the beginning especially, we may want to gather our volunteers with a board member and myself to come together and work on additional questions. That would mean that without having the contractor necessarily involved with that piece, we could come together to do the additional questions and have a better database. When you involve the contractor, they'll probably do this once a year. I think at one place we've got once a year for a while with them doing it with us. But this wouldn't be to look at the bad questions as much as potentially get additional questions that then we could give them to review for true psychometric, clarity.
I think where my question came in on this was it gives me the appearance that the board designee, whoever that might be, can on their own reject a question without the board's input.
But only if you've designated them to have that power.
Okay.
They only can reject and review and all these questions if the board has approved this person to have that power.
Okay.
So,
If it's so stated that way, Ms. Martin, then that'd be fine. But I have to agree with Jay. I think that leaves it open if we don't tie it down. And I haven't seen where it's tied down anywhere.
how about the board on its own? We'll just get rid of the designees and just say the board may, on its own initiative,
I'm more comfortable with that.
review questions on its own initiative, with, so how about this? The board on its own initiative with designees, with board designees, saying that you can designate someone to do this. So it's on the board's initiative, and then after initiative, I'll say with board designees.
Instead of the or, you're taking out the or.
Yeah. So the board, on its own initiative, with board designees, may review questions which were previously approved.
As long as the designee does not have that power by itself.
Thank you. That's what I'm after.
Right.
Yeah.
I got you.
Well,
And gentlemen,
the other side of this issue, Miss Martin, is the heartburn that I suffer over the fact that if the board, as a unit, discusses a question, it has to be in a public forum, at a public meeting. The question is no good at all at that point.
Which is the point of allowing you guys to have designees, so that one of you can sit with two people who are not board members to discuss this.
Right.
And then a week later, another one of you could sit with those same two people and discuss another question. That's why we want to make sure that you have the power to designate persons to do this work in conjunction with board members.
yes, and gentlemen, if I may speak to this language that Ms. Martin has included here is very standard across all of our boards, that they allow this to allow for these functions to occur, to continue to maintain the integrity of your test and not have any of your questions publicly discussed, where they basically you're unable to use them at that point because people will know the answers to them. So again, this piece is not written just for your board. This piece has been written for all of our boards, and this is typically what those boards do. And this process has been very successful.
Okay, I tell you, I like the way that Laura rephrased it there a minute ago, and the fact that, and Galen summed it up exactly what I'm trying to say, is that the way it's worded right now, that allows for at least the way I interpret it, the board's designee to take this on their own with their own initiative and have the authority and power to reject or request modifications, as opposed to the way Ms. Martin had rephrased it just shortly ago. I wish I could say it the way she did.
Here, I'll reread it for the record for you. I'm going to write it as the board may on its own, the board on its own initiative may review questions with board designees which were previously approved, so on and so forth. Does that read?
Yeah, I'm much more
Okay.
comfortable with that.
And remember that it's never one person reviewing and deciding what's good or bad. So by designees, we generally are going to mean a board member, probably someone from the office, myself, I would imagine, or someone that's the expert in this. And then 2, 3, 1 volunteer. These experts are going to be, those are your designees.
Okay.
Yeah.
And if I can just kind of follow along in the second sentence, where it reads, such reviews may occur no more than every 6 months unless the board, I'd like it to say unless the board and the board designees, as opposed to or. Again, trying to get away from the appearance that the board's designee could have the sole authority.
To and.
Just make it an
Yeah.
and instead of an or.
Yeah, I agree with that, Jay.
Or along with, or in concurrence with, or however you phrase it. Okay, Tim or Galen, anybody else have any more comments on that last paragraph on that sheet?
I'm good.
Okay.
I'm good with it.
All right, jumping over to the next sheet, section A2E, I did not have any comments.
Nope, I don't have anything.
All right, jumping into section A3, exam administration, I did not have any comments on A3A. I was comfortable with it.
On A3A, I had one comment. It states that the contractor shall notify, that may have been changed.
I didn't change that, Mr. Lingerfeld. I kept that the same and wanted to talk, Roxanne and I were going to talk to you about that. The contractor does notify the candidate. Having the contractor notify us and then having us notify the candidate would be, it would be kind of against standard practice. Usually the vendors will notify someone if they have failed or passed the test, and then they also release a list to us. But that way we're not contacting someone to letting them know if they have failed a test or passed a test.
Okay.
Is there an issue or?
Well, I just wanted to make sure that it was not procedural with Roxanne's office.
Right, right, and it isn't, because we're the licensing piece, rarely would we need to be involved that early in the results of the exam. So they'll have a method with which to post online for licensees to find their responses. And they, right now, send out either an email or a postcard because these exams are due to the map layout and the plat information, they may not be able to be immediately have a response. And some of the boards you have, you immediately know your score and you know if you passed or failed. That would not be the case here. So we're giving them a time frame of a pretty quick turnaround, but very similar to other professions, they can go to a website or actually get something in the mail. We'll want that to take place, but the board can also access that information periodically as well. So we can have that as a practice. But right now, I'd hate to see us be that first line of contact and then us informing the candidate, that they passed or failed, because then we're getting into a conversation about what did they miss and all this stuff.
Okay.
Yeah.
Okay, I'm good.
Oh, yeah, I think that's good.
Okay, good. All right, moving on to A3B. The only comment I had written was in the last sentence where it reads, as well as examples of questions to be included on the examination. I'd like to add in there for it to read, as well as examples of questions similar to those included on the examinations. Because to me, the way it reads, as it is now, it gives the appearance that actual questions from the examination will be included.
Okay,
Right.
we can change that.
And so the best way I could just come up with was similar to those, or of similar
Mhm.
fashion, or of like fashion, or something like that.
Similar to those included would be good. It's
I just
straightforward.
didn't want to give the appearance that we were giving them actual questions. Okay, any other comments on A3B?
I'm good.
I'm good with it.
All right, A3C.
So Tim had actually submitted a comment about this one.
Okay, yeah, please.
And I think we need to go over this because right now the fee for the exam is $150 and that fee is set in our rules, which means we can't have an applicant pay more than $150 for the exam.
Correct.
So we have to continue to like honor that until or if we want to change that rule.
Correct.
And the way that we're writing this RFP, this request for proposal, is the idea that the board is going to have to subsidize the test provider. And that's kind of something I think we're already doing. I think we're like already the money that we have been paying to Mr. Messier was sort of supplementing what he would be able to collect from test takers. So I understood your issue because yeah, 150 isn't going to cover it, but there's not a whole lot we can do about it since it's set in our rules.
Well, if I may, Ms. Martin, at our last meeting, I had a pretty extended discussion with Mr. Driver about this issue, and I came away with the understanding that the state, irrespective of the fee that's in our rules, had the ability, because it was going out to a contractor, had the ability for the contractor to set the fee for the examinee. And that's really why I'm asking that question, because I queried Mr. Driver more than once at our last meeting about this issue.
So I think that maybe there was like some confusion. The problem is that Michael Driver, he was right in saying that the problem is we can't do that until we've addressed the fee in our rules. So, for instance, we could change our rules to say that the contractor can set the price, but right now we've set the price. So we can't charge the applicant more than what we've said we're going to charge them in the rules.
Well, they kind of handcuff this in a way, but if it is in the rules, it's set.
Well, wait just a second. Help me here. Help me just a minute, please. The FS exam is more expensive than the rules, and the PS exam is more expensive than the rules. And they're provided by an outside vendor. So what am I missing here?
Well, and we're supplementing that now. I'm going to let Kimberly, because I know Kimberly answered and actually gave you the dollars and cents of how much we were supplementing now anyway. So I'll let her kind of answer it.
Yes, sir. We don't have the fact that it is set in rule means that the fee shall be $150 in order
To the person.
to the person taking the exam. There's no way around that at this juncture because it is set in rule.
Okay, well, again, bear with me, my ignorance, but how is what we're doing different than what we did on the FS and the PS?
Those are handled through the fee for the FS and the PS. I don't believe are set in your rules.
Yes, ma'am, it was. Let me get my rules.
We no longer offer that test, though. We definitely are in the process of changing those rules because we no longer, but those tests are now through NCEES. It's not as if we have a contract with NCEES.
We do have a contract.
We have a memorandum of understanding.
Right.
And there's no cost involved. We don't pay them. That's why sorry, Kimberly. That's why in the current rulemaking, we're trying to redact those.
That's
But this is different because the state and the board is still directing this. We're still collecting a fee. We're no longer collecting the fee that they're taking for the FS and the PS. It's not great practice that our rules say one thing and in practice the applicants are stating another thing. And we're doing what we can to rectify that. The difference is we're not actually the ones that are setting that fee. We haven't set any contract. We haven't agreed to that. That's just something that happened before the law could catch up with it. If we were to send out a request for proposal to do something that violates our own rules, then we would be kind of in trouble. Because then we would be trying to collect a fee you know what I'm saying? We would be collecting a fee that we've set in paper that goes against our own rules. Does that make sense to you?
Yes, ma'am. Yes, ma'am, it does. You said it very clearly. I do understand. However, I do feel like that we are in some way violating our rules but apparently it's the opinion that since we have a vendor that provides this service and we're not providing it, that we're not violating the rules. But you see, heretofore, we charge. For example, let me give you an example. Our rules say that the PS examination had a $150 fee. NCEES provided that examination since 1978, I believe. I may be incorrect about that. Maybe it was 85. Anyway, they provided it for almost 30 years. And we've had an examination fee. And now the only change is they're still providing the test, except you got to pay them for it. But we never wrote that test. They have written it all along. That's why I'm questioning this process.
I'm not sure how to answer that question. I think I've told you that it's bad practice that we have a rule saying that it's $150 for that test when that's not actually what applicants are paying. But that's kind of something we didn't have any control over, and that's why we're trying to redact those rules.
Okay, so...
But here, this would be a different situation because right now we're sending out a request for proposal asking people to bid on something, and we would be saying, hey, we're going to put this out for something you can bid on where we're consenting to the violation of our own rules. With the NCEES test, I don't know that we have the same control. So all we can do is work to catch up to it.
I understand. So the moral of the story is we need to get this form, get it out, see where we're at, and then look about working with this rule about what the fee is if we need to make changes because of what the result ends up.
Yes, you're absolutely correct. And also, but keep in mind, this isn't kind of a new problem that we're picking up the additional cost. We've been picking it up. We've just been paying it to one individual instead of whoever puts in and wins this contract. So absolutely. Yes, yes, sir.
Okay. Can I ask another question on the same subject here? Laura, is it necessary to include the verbiage here that reads, "It is understood such amount is currently $150"? Is that really necessary to include in this? I mean, I understand it's for information purposes. I understand it's for clarity purposes. I understand all that, but is it necessary though? I mean, if you feel it's necessary, say you feel it's necessary. Laura.
Sorry, yeah, I'm just
I
trying to.
think that would actually probably be a question for our central procurement office. So right now, this is Kimberly. I would err on leaving it in,
Okay.
and we can certainly ask that question of that group, but I don't feel like it's our place to speak. We've tailored this contract, the verbiage in this scope piece after other contracts. So
Okay.
just to be cautious, if we don't, if it were, this would potentially could be the only place that it appeared. I believe it is in the cost portion, but
I would so, yeah. Okay.
just
the
to
way I
make
read it, just
to make it
didn't
clear
seem like it was
to
necessary.
those proposing that this is the limit of what can be assessed.
Yeah, that's fine. Okay. I mean, if it needs to be there, that's fine. I have no problem with it. It's just the way it read. I didn't think it really was necessary.
I can ask if it's essential. I know that a lot of effort was put into clarity. Believe it or not, I'm sure as you're reading it, you're surprised. But I can ask them if they think it's essential. So I'll just put a question mark next to it for now.
Okay, I just have one last comment on this section 8.3c. The last sentence in 8.3c didn't seem to flow with the core meaning of the paragraph. I thought maybe it should be either a separate paragraph itself, or really I thought maybe it should be a whole separate section itself. I don't see where, all of a sudden we jump in here about retake rules established by the board. What that has anything to do with what's written directly above it. I didn't see the flow.
I think that speaks to the registration process and that the candidate shall register with the contractor. So I believe that's why that's been included. I mean, it certainly can be
I just thought it was the way I read
separated
it.
from the others, but that's what it is referring to.
Okay.
Would you like it to be its own thing? I could make it A3D and then renumber everything down if that's what you prefer.
That's what I had kind of hand scratched in there was that by itself. It's an important piece. It needs to be in there. But it just didn't seem like it flowed. But if somebody reads it otherwise and is comfortable with it, I'm fine.
And Miss Laura, that language was modified from the previous language, also, wasn't it?
I'm sorry, say that again?
Yes.
From the first gyration that we got of this, that language was modified.
Yes.
Okay.
I think so.
Okay, moving on to A3D. I'm comfortable with the first sentence, The second sentence, the contractor shall resolve candidate concerns in a timely, efficient, responsible manner. I was good with it until I came up on A3M and A3N, which are all kind of redundant. They kind of say the same thing three times in a sense.
Yep.
And again, I have no problem with it being there, but it just kind of says it again and again and again when really you just need to say it one time, I feel. But if there's other meaning behind it, please let me know.
Okay. I think that we should leave at least the first sentence of A3D providing the toll-free number.
I agree.
And then when you go to A3M and A3N, if you wanted those consolidated, we could. The only difference between them is one is saying inquiries from exam candidates versus exam candidates who have already failed. But we could say respond and resolve inquiries from exam candidates and candidates who have failed within 5 business days.
Yeah, I think. Make one. Absolutely, just wrap it up into one section there, as opposed to saying it 3 times. I think is better.
Okay. We're gonna.
Still there?
Yeah, sorry, my mic went off. So we're gonna consolidate A3M and A3N, and then in A3D, we're gonna leave the toll-free telephone number portion.
And you're just going to take the last sentence out of A3D.
Correct.
Okay.
I really think you should leave the sentence in A3D just because that's related to people registering, and I think that's different than people who I think the consolidation of the next two is appropriate, but I really think you should leave the D because you're wanting them to be timely with responding to any questions that applicants have. That would be my suggestion. It does seem redundant, but it is talking about two different sets of your population.
That's the way I read it, Miss Kimberly.
Okay, I just think that I know it. Sometimes contracts are very redundant in that, but we'd rather have more than not enough.
Okay, that's fine.
Okay, I understand that too now. I didn't realize that I was kind of in line with Jay with that. I think combining M and N are okay, but yeah, probably leave that the second statement in D is probably very appropriate too, based on what you're saying, Kimberly.
Yes.
Any more comments on A3D?
No.
All right, we'll move on to A3E. I guess my only question really was, what is a photograph bearing score report? I imagine that is just what it says, a report of the score with an actual photograph of the person?
It is, and we can actually, the next time you're here, or I'm sure Roxana has one, it is a security measure that they put in place, and this is standard with all our computer-based testing vendors, that they take a picture of the person. For fraud purposes, if someone were to say, oh, this is who it was, a male shows up and takes a test for a female, they have the picture, and they also compare it to their photo identification. So that's all this is. It's standard, and all of them provide it.
Okay, it makes sense.
Sounds good to me.
All right, A3F. I think my only question really was, what defines all candidate information to the state? What I assume that to be is the candidate's registration information when they signed up with the contractor. Is that correct?
This is very open-ended and allows for the board office to meet the needs here for us to request from the vendor whatever information they have captured or request for them to capture something specific, such as an email address, a mailing address, date of birth, social security number, that type of information.
Right. Is this intended to be a shall type statement or a upon request type statement?
This is sort of assumed. This is part of what they send us. Roxana alluded to this earlier about the fact that most of the computer-based testing companies, if not all, I'm going to say most just to cover myself, have a portal that the staff uses to go in, and we can actually look up people rather than them having to transmit, but the transmission is part of that electronic, that they post that for us to be able to see it. So in years gone by, it would have been electronic. In years gone by, it could have been them sending us a fax. This statement allows for whatever information we need, and in the manner that best meets the needs of our business to best serve our applicants.
Okay. All right, I'm comfortable with that. Anybody have any other questions?
I'm good.
I'm good with it.
All right, A3G. I think the only question that came on this was, what about if there's costs incurred by the contractor in the defense of any legal challenge? Is that addressed somewhere else, or is that assumed to be in an additional expense? Is that assumed to be in the fee that they're paid by the contract already?
Well, that goes back, Jay, to the psychometric analysis and so forth for the examination, so that the exam at the end of the day is defensible.
Okay, it just seemed like the statement was left wide. It may have been on purpose, and I think maybe that's a good thing, but it was just kind of left wide open instead of, to what extent do they have to provide support or participate in the defense? It really doesn't give any a definition of what those are. And again, those are hard to define, so maybe it was purposely left.
This is kind of like an indemnification clause. Basically, what we're saying is if somebody sues the state because they fail the test, the contractor is agreeing to help defend that suit.
Okay, all right. I figured that's where it was going. I just want to make sure I understood it. Okay. Any other questions on A3G?
I'm good.
Good.
A3H.
This is the one that Tim said he felt conflicted with A to B.
I believe.
And I think the corrections that we made in A2B, if they're made here, I don't want to speak for Jay, but if they're made here, I think it'll be fine.
Yeah, I did have the same comment down. I think it's in the last sentence where it reads production or correction of a deed description. Again, the same correction that I mentioned earlier. It should be a land description. And then also, as you read further on that same sentence where it says production of a subdivision plat, just by removing the word subdivision.
Right.
Yeah, I agree with that.
And one more item here on the very first sentence: administer all examinations. Period. Each exam taker. Is that the same as what we've been referring all along as candidate?
Yes.
Yes.
Would you like to change it to each exam candidate?
I think to keep it consistent, so there's no.
I agree.
And then also, Tim and Galen, I need some help on this one. About halfway down, it mentions basic drainage and hydrology, which I understand. Characteristics and use of the Tennessee coordinate system. I assume we're referring to state plane coordinate system. Is that correct?
That's correct.
I would assume so.
We have a section in our rules, Jay, that's what it calls it.
Is there a better name for it than Tennessee Coordinate System?
I want to keep it consistent. If that's the way it's referred to in the rules, I want to keep it. But I think everybody, or at least most people, refer to it really as the Tennessee State Plane Coordinate System. I wouldn't want to lead people into thinking, oh, that's some other kind of coordinate system they didn't know about.
What if I put Tennessee Coordinate System and then in parentheses I put Tennessee Plane Coordinate System?
State plane system.
State plane
Just the state plane? And when you say plane, do you mean like PLA? Any? Okay.
Well, Jay, 66, 6-105 and 106, actually 106, speaks to it as the Tennessee coordinate system
of 27.
Gentlemen, I believe this particular section may be an exact quote, or should be an exact quote, either out of your law, as Mr. Lingerfeld, I believe, is pointing to, or out of your rules. I feel like it's a quote.
I think we should leave Tennessee Coordinate System, but if you think that it's clearer to then put in parentheses the plane or the state plane system, that's fine. I just don't want to substitute it.
I agree. We want to keep it consistent with what's in the rules, and it does say, I'm looking at the same one, 10.666.106. It says in quotation, Tennessee Coordinate System of 1983. Yes, the way it reads. And I think if we're going to keep it consistent, let's do that, such that it reads Tennessee Coordinate System of 1983.
Okay.
And I think that covers everything. I think that should make everybody comfortable with it. We all know what we're talking about.
I don't have any heartburn with that either. I think that specifies exactly what it is.
It's prepared. Yeah.
And then, Tim, you'll notice at the bottom of A3H, I added the sentence making the exam clear that it's closed books. And then no books, examples, or other study materials shall be allowed to accompany the, I guess I'll change applicant to candidate for consistency.
Yes, ma'am.
Yes.
And also, does it address in a roundabout way the use of calculators, pencils, pens, anything that they can bring in, or is our intention that they are to come in with themselves, and that's it?
That's one of the questions actually I have regarding this is what truly is necessary, / is there something else in addition to the computer that we're asking the vendor to provide?
Well, let me give you the NCWS example. NCWS provides all pencils, all scratch paper type items, and they actually keep those, like pencils and scratch paper. But the candidate is allowed to bring in an NCWS approved calculator.
Yes.
So is that what we want to then mirror to get this?
Yes.
This is guidance. This is definitely guidance for the contractor. So
I think we should word it exactly the way NCWS has it.
Want them to only be able to bring in their NCWS approved calculator.
That's correct. Everything else they need for the exam will be provided for them by the contractor.
right, and scratch paper and pencil. We are expecting the vendor to provide that.
Yes, ma'am.
Okay, and there is nothing else between scratch paper, pencil, and that calculator, aside from the computer and the actual test that they should need.
That's it.
Okay.
So,
So here's how I'm going to write it. I'm going to leave exam shall be closed book. No books, examples, or other study materials shall be allowed to accompany the candidate in the test room. And then period. Next sentence. Candidate may bring an NCEES approved calculator. Contract will provide all other materials required for exam.
I think that'll be fine.
Okay.
Yeah. I agree with that.
Okay, let's move on to the next page here. Top of the page, A3I. Maintain staff permanent testing site. I did have a little bit of heartburn over how specific it gets into Nashville, Memphis, and Knoxville. What I would suggest is permanent testing site in each of the 3 grand divisions, because otherwise you are specifically narrowing down this contractor to those 3 cities, whereas there may be a more convenient or more cost-efficient example in, let's say, Murfreesboro or Jackson, Tennessee, or other suggestions like that. I think by saying in each of the 3 grand divisions, you are covering Nashville, Memphis, and Knoxville, which is the intention of, area-wise, and obviously the largest cities.
I can just. Are you okay with that?
Just a suggestion.
I'm fine with that. Again, this is boilerplate language that we use for our computer-based testing. But if you would like to do the grand divisions, you're certainly welcome to.
Well, I'll have it read: maintain and staff a permanent testing site in each of the state's 3 grand divisions, with testing available and then so on and so forth. Are you okay with that, or do you want me to say in east, west, middle? Or are you okay with the 3 grand divisions? Okay.
Yeah, each of the 3 grand divisions, I think is fine.
The 3 grand divisions keeps it simpler.
I think so, and it allows some options there, but still keeps it concentrated in the sections of the state there. Okay, any other suggestions on A3I?
No, it looks good.
Okay, moving on to A3J. I did not have anything written down on that one.
I don't either.
Okay. A3K, regarding the ADA requirements, I think that's probably boilerplate. Have certainly no opinion there. I'm fine with that.
Yep.
Let's see. Okay, A3L, score the examinations. I did have written down here, when does it go to the candidate? I had that written down. Score each examination given and provide the written notification of the candidate's scores to the board within 7 working days. Okay, so the scores are going to the board within 7 working days, but when do the scores go to the candidate? Because isn't it, from what I understood earlier, the contractor sends the scores directly to the candidate as well.
That is correct. That's the way we'd like to go, is have them send it directly to the candidate. So we probably have to make this consistent.
We do need to make it consistent. The only thing there would be written notification. I mean, written, of course, can also mean electronic means of communication. I'm not sure if 7 days. If they did have to mail.
About when they tell us, he's wanting to know: are we going to put
Right.
a limitation on when they tell the?
Right, and that's what I'm getting to, is the fact 7 days for if they did have a candidate who did not provide an email address, the hopes would be they would, but if they did not provide one within 7 days, they could distribute it within 7 days. The candidate receiving it within 7 days, that would probably be a stretch with the U.S. Postal Service.
Provide written just means that they've got to get it out the door.
Right, if that's how we want to.
Yeah.
Yeah, I'm fine with all that. My question really is,
We can just add in that statement to the
First to the candidate.
candidate as well.
thank you. Yeah, that's what I'm after.
Yeah.
Yep.
Yeah, that was
Nope.
only addressing the score to the board. It was not addressing how the score or when the score goes to the candidate. So, yeah.
And with that, the system that Roxana alluded to earlier, typically it is faster than 7 days, and it's immediate for us because it's posted to their online system.
Right. Okay. Any other comments on A3L?
I think that's good.
Okay. A3M, A3N, I think we addressed earlier. We were going to consolidate those two. Is that correct?
Yep.
Right. Okay, is there, okay, moving on to A4, exam security. I did not have any comments actually through any of the items. Well, obviously A4 only has A4A. Was there anything there, Tim or Galen, that you'll?
No, I'm good.
I'm good with those.
Okay, it looked like A5, A6, again, looked to me to be standard boilerplate. There was nothing specific really in the surveying there, so I personally did not have any comments on those either.
I don't have any comments on them.
And you are correct in the boilerplate
Yeah. Okay.
legalese.
Okay.
That covered everything that I think really was specific to the surveying, unless there was something I missed further into the RFP. Was there anything, Tim or Galen, Roxanne, Laura, that we need to be addressing outside of what we just covered there?
I had one additional item.
Sure.
It's into the next section B, term of contract. Yesterday, when I was discussing this with our contracts attorney and Michael, they wanted to make sure that we discussed how long you want the contract to be for. So their suggestion had been that we have the contract be for 3 years with the option of 2 renewals.
Okay. The current one that we have with Peter, I know we're in a renewal right now. Is that correct?
We did an amendment
Okay, that's right.
that has expired. It reached its 5-year limit.
Okay, so what was the length of his original contract? Was it 3
His
years?
original contract was 5 years, Jay. The amendment was to add an exam, if I'm not correct.
Yes, and I believe his previous contract prior to this 5-year was actually a 3-year.
That's correct.
Mm-hmm.
Based on my review of the invoices, that's where I discovered that. So yeah, this is the 3 years with the 2-year extension gets you to the max of 5. So that's standard.
I think at that time, if we want to address the pool of questions or anything like that, it gives us that flexibility. And if for some reason the rule is changed and we need to, and have the option to change that amount so we subsidize less, then at that point, I think it's a good chance to review it and make a change so we're not picking up such a huge fee.
Yes, and should you change the fee structure, we would have to discuss with central procurement about how to potentially an amendment to the contract. But again, that all hinges, and rules take time. So, this should allow plenty of time for this to settle in.
Okay.
All right, as long as you guys are okay with that, that's fine. That was just something that came up yesterday that they wanted me to double check with you guys.
I'm comfortable with that. I think that's fine.
Yeah, I'm okay with it.
I'm good.
On the renewal options, is that upon agreement? I assume it's upon agreement of both parties for a renewal.
Yes, both the state, which in this case, we would present that to you at a board meeting, letting you know that it is up for renewal, address any concerns at that time, and then proceed with a process very, very similar to this for the renewal, but much simpler.
Okay. Yep. I would certainly assume that the contractor has the option to not accept the renewal, obviously.
Yes.
If he fulfills his 3 years and he says, I think I've had enough, I'm out, but the state says, no, we want to keep you, he certainly has that obligation or choice among himself to say thanks, but no thanks.
Yes.
Okay, I figured.
I think we've only had that 1, maybe 2 times, and it was really because of a total change in business model.
Mm-hmm.
So.
Yeah, I was thinking.
And we secured another vendor in that case.
Yeah.
To provide the service.
Okay. All right. Anything else elsewhere in the RFP that we need to cover? I think we've covered the majority, if not all, of the scope really that was directly effective of the board. Anything, Tim or Galen, you need to add to it?
No, I'm good, Jay.
I'm good with it, Jay. Sounds good.
Okay.
Laura,
But
again, Laura, just outstanding job here. I know certainly it's a team effort. It's not all you, but certainly I want to give you the lead applause for all the work that's been done here. It's fantastic.
I appreciate you saying that. If you guys are good with what we've got, I know that Tim is running out of time.
It's fine,
So
it's fine.
what we need to do before he has to go is have this be adopted with the amendments made today by a roll call vote.
Okay.
So whenever you're comfortable, if you're done with discussion, if we could have a motion.
I so move.
I'll second.
Okay, and I will do roll. So all of the notes that Laura, Kimberly, and I have taken, we will revise the RFP and propose it as the board has reviewed. We have a motion by Mr. Galen and seconded by Mr. Tim Langerfeld, and I will do roll call to make sure that everyone is in agreement. Mr. Jay Kaufman,
Yes.
Mr. Galen Northcutt,
Yes.
and Mr. Tim Langerfeld.
Yes.
All in agreement for the process to continue with the RFP as the revisions have been made? Thank you.
Very nice.
And will you send that revised thing out to us and let us take a look in case there was something that we just inadvertently blew?
Yeah.
We can send it out, absolutely, but as far as actually making changes, unless it is something just catastrophic based on this vote.
Yeah, I do understand that, but I think that, if we see something on there that has been inadvertently put in and are left out that we've been talking about, I think just one review and then I ought to turn it loose.
Okay. Well, if there are any of those changes, it will require another meeting.
To
make a
I'll
change.
Send you, once I incorporate these changes, I'll send you the new document. And if there's any issues, we can talk about what
Yeah.
we can do.
I mean, if we need to do that, then I think we ought to do it, but I really don't anticipate it would be.
Okay.
I just thought it'd be just good to review.
Okay. I appreciate all of your notes. It was very helpful. I think that this is going to go out very clear, very good.
You did so
Ladies,
well.
thank y'all for all your work.
Thank
Thank you
you.
very much for being available. We need a motion to quickly adjourn.
So moved.
Second.
Mr. Langerfeld and Mr. Galen seconded. Thank you very much. You all have a wonderful Thanksgiving. Thank you for being available.
Thank you, gentlemen.
Bye-bye.
Thank you. You too.
Bye-bye.